you probably know it's a kind of fungus. Sometimes people say mildew. That is a kind of mold. Um, and mold can be indoors or outdoors. And the biggest factor with mold is moisture. So anytime you have leaks, you have excess rain, you have any kind of moisture situation, you know, obviously immediately there's the damage that causes to the wood, to your personal property, and to the premises. That's the immediate thing that you can see. But if the moisture is not completely treated, eventually what you're going to have is mold grow. And we have seen an increase in those kinds of cases come in. And sometimes you can see it and sometimes you can't. Um, but these areas are, this is something that we're seeing more and more. Yeah, so we're going to get into the legal complications with mold, but the best thing that we can do is avoid having it. And unlike a lot of conditions cases, there are things that the tenant can do and actually are responsible for in helping to prevent mold. So some of these things are landlord responsibilities and some of these things are tenant responsibilities. But making sure that you're controlling the humidity levels, not opening the doors and windows all the time can help do that. Obviously you're going to need air conditioning in July. So that could be the landlord's responsibility depending on the lease. And then obviously anytime there's any kind of leak, anytime moisture is getting inside the residence, getting that fixed very quickly is huge. Several days of delay can end up causing mold that you won't know about for many weeks. And the tenants, can really help out by making sure they are thoroughly cleaning surface areas. They're keeping their residents in a good condition, especially where there's water, kitchens, and bathrooms. And if the tenant's able to show that they're doing that and that they're not part of the responsibility for the mold, that can really help ultimately in getting a favorable decision in a case. A lot of times people read, they Google, they use AI assistants, and they find some kind of rule about molds, something that is a landlord's responsibility or something that says this is what you do if you have molds. But really in North Carolina, there's not a law that specifically addresses mold. And some states do have statutes. They have codes that specifically are to address the complications with mold, but North Carolina does not have that. So we're going to be relying on statutes that really are about more broader issues that are not specifically designed to handle the difficulties that can arise in a mold case. So we don't have national state codes that will define, what mold is okay and what mold is dangerous, what specifically happens when mold needs to be remediated, how a report would be generated that you might use in court. And so a lot of the reasons that these cases are so difficult is because North Carolina just doesn't have a statute or sets of regulations or housing codes that really try to get at this issue. And so we're left with what laws we do have about conditions, personal injury, negligence, habitability, contract law. We're looking, in those areas of law to apply a mold case and how that fits in. And to be, honest with you, it's very difficult. The fact that we don't have clear definitions, that there's some ambiguity and some vagueness, it really does make the case harder to win. So the one thing that we can rely on, and this is not just for molds, but this is in Chapter 42 of North Carolina law, and it's unwaivable. The landlord must provide a safe and clean premises. And so even if a lease tries to disclaim the landlord's duty to keep the place fit, habitable, safe, clean, that's not going to be an enforceable provision in the lease. So regardless of whether it's spelled out or not, the landlord must do these things. And what is defined in the statute is providing heat, providing water and power access, and there are several other things that Chapter 42 will basically require a landlord to do regardless of the situation. And unfortunately, this is the strongest law that we have to require landlords to address mold. While mold's not specifically in there, the argument would be that if you have dangerous mold that is causing safety issues and is not a safe or habitable environment for the tenant, then they're violating their duty and their unwaivable duty to provide a habitable premises. And so this area of law is really the what we're going to mostly be able to use in mold cases. Yeah, so here's a little bit of law on mold cases. And this case is essentially where they were able to show that the landlord had been notified about the mold, that they knew that there was a problem, that the mold was potentially a dangerous situation, and that created a negligence situation of the landlord where they had this normal duty of habitability. Then they were put on notice that they were potentially breaching it and that it was not a safe situation. And we'll talk about how to do that later in this presentation. Then they failed to do anything about it in a reasonable amount of time. And so that created this breach of the warranty of habitability and allowed the tenant to recover. So that's the difficult burden that you have. And the other part of that is it's going to be limited to sort of contract damages. So the maximum amount under this theory that you can usually get is the amount of rent paid. Obviously, if the mold is causing health issues and you've had to miss work, you've maybe lost your job, you've had medical bills that have stacked up, all the things that you'd associate with personal injury cases, you really are not going to have a chance to recover those under this implied warranty of habitability. It's going to be limited to contract damages, the lease that you have, and how much rent you have paid. And this case sort of establishes that while you can get a landlord for molds, you got to do all these things first, and then even then your recovery is somewhat limited. So one theory to go around that or to get more damages is to argue that the landlord is, because they've continued to charge you rent, they've known about this mold, they've not done anything about the molds, and they know they're on notice that it's dangerous, and they still continue to charge you rent. So that theory, that could lead you to beginning unfair and deceptive trade practices claims against the landlord, which would give you a chance to get more money in recovery because there's a chance to get attorney's fees and treble damages, particularly if it's a very deceptive and unfair practice by the landlord and you have all the evidence to show that. I mean, you see here, even the case that gives us that language that lets us know that this is the kind of case that we could bring against a bad acting landlord who's really not doing anything about molds. You have to make sure that you check that uninhabitability box. And in that case, in the Elder case, they found that it wasn't uninhabitable. And that goes back to where the statute doesn't mention mold. Even though a place was covered in mold, it was really bad. It was not held to be the same as like not having water, not having electricity, not having heat, having a huge hole in the ceiling. So that judges were finding that place was, while not repaired properly, that's not quite the same thing as having a place that basically is not fit for habitation. So this obviously it will really matter. The facts will really matter. Who your judges will really matter in how this plays out. But it's just this is how you might recover more than just your rent, and it's still going to be pretty difficult to do. So there is also the opportunity to go outside the contract law world, to go out of landlord-tenant world. And I'm only going to just mention this because truthfully, Pisgah Legal Services, we might partner with somebody in an egregious case that starts off as a landlord-tenant case, but really does have more elements of personal injury. And so this is where you would try to go at the landlord for committing negligence or gross negligence, which is often required in a landlord-tenant type case. You're not usually able to get you're not usually able to get into tort land or negligence land because of the contract sort of defining what the duties are between the parties. But if you had something really egregious, you might be able to sue the landlord for something like that. but it's going to be kind of even a higher bar because one, you have to get in, you have to kind of show that the contract is not covering all the liability and all the duties for the parties. And if you're able to do that, then you still have all of the things that are difficult about showing negligence. And I'll talk a little bit about that towards the end, but essentially, it's very expensive to properly test mold that where the test and the experts who have done the tests can come to court and get the evidence admitted. And the harm part, the fact that what mold is causing physical injuries, personal injuries, that is even harder from my understanding. Just because you'd have to have the doctor's note, and it's very, the doctors come and present evidence, and oftentimes it's really difficult to tell whether it's molds, where you got the mold problems, because there's mold everywhere outside. And so it's not impossible, but you really got to have very strong evidence to win those kinds of cases. And if there is personal injury and there is our medical bills and lost work, we do still want to get those cases, but we'd be looking to partner with one of our mountain area volunteer attorneys that who does personal injury cases and might take the case with us. So I think these are the big things for our clients, our applicants, our partners to know when you hear about mold cases. Obviously, we want you to refer them to Pisgah Legal to see how we might help. But as you're not providing legal advice, but giving information to people, I want to make sure that tenants know that in mold cases, there is a threshold question of who's responsible, and tenants have certain responsibilities to keep the place clean. And some mold cases die very early on because the tenant is blamed for causing the mold or for not reporting the leak or for not reporting the moisture and the mold that comes after that, where if the landlord can argue they had known about it, they would have done something about it. So it's really important if you have somebody come to you, like make sure they have communicated in writing to the landlord about it and that they have done everything they can, that they've tried to mix bleach and water and wipe up everything, that they've gotten to places where they can reach, certainly not within walls, not above the ceiling and not below the floor, but anything that's a surface area where they can get to, they need to be trying to help with that. To take pictures, the client's testimony is a very powerful piece of evidence, even if you don't have other things. But the picture is worth more, usually just because if they deny it, having some other evidence will be helpful. And if they take the picture, likely they can't get that admitted. We don't recommend buying store-bought tests. One, they're not very accurate. So there's a problem with their admissibility just based on like whether or not that test really can be relied on. Also, there's a chain of custody issue. Like there's so many issues in getting that kind of evidence, a store-bought mold test that you could get at Ace or Home Depot. It can be a way to get the landlord's attention. So I wouldn't say don't do that, but a moisture meter is probably a better thing to do at that point, to try to test whether there's moisture like near the walls or under the floors. That kind of thing is actually probably more reliable and like showing the landlord there is a problem they need to do something about. So you generally tell people that even if you do it, that's not the silver bullet. The fact that it shows some kind of mold will not necessarily be enough. And then, the other problems with personal injury cases and these cases in general is all that kind of stuff is expensive. There are professional remediation contractors that will come in and do this. They will do accurate tests, but those tests are more expensive. The companies that specialize in it and the services they provide are not cheap. A lot of times for our clients, they're not really accessible options for them. And then sometimes you have to get them to come to court, which also can be expensive. And then the health issues, the causation issues I was talking about earlier, your doctor, if you have a physician who's, confident that the condition you have is being caused by a certain kind of mold and you have proof that that mold is in your premises, like you're getting there. That's a good start. But you have to remember that if there are other things that are contributing to that, that can reduce your ability to recover.
Well, thank you so much, David. David is the director of our housing team here at Pisgah Legal Services and does so much great work to protect tenants and educate folks in the community. So, thank you, David, for taking time to share this information with us today.